Good morning from me too. I would like to thank Professor Tsutsos for this invitation. It's an honor and a pleasure for me to be here. We are going to make a presentation in two parts. The first part will last for 30 to 35 minutes, and then we shall have some minutes for questions. However, it would be preferable if you have any questions during the presentation, please do not hesitate to interrupt me and ask your question. This is the best thing for me. I would also like to apologize because only this morning I realized that Professor Tsutsos had sent me a template of the presentation. So there wasn't any time left for me to transfer all my presentation to the new templates. Therefore, I only took the first and the last page. Sorry about this, Professor Tsutsos. Okay, I hope this doesn't cause a problem to you. So I think we may begin. Sorry, I had to take off the screen all these things. I don't know how to do it. Okay. I don't know how to do it. Okay, I managed the first one. Well, these are the contents. We are going to see 8 points. I think these are the most crucial points for someone who wants to make a patent. Either he is a researcher or he works in a TTO office. I will put the time. So, first we shall see the intellectual property rights at a glance, just an idea what is the intellectual property rights, the IPRs. Then some examples of the inventions linking material sustainability and cultural heritage, just examples. Then we shall see the 3 prerequisites that have to be present, all the 3 of them, in order to get a patent. And then we shall go to the protection of the invention and the procedure to protect it, how you get a patent. So, intellectual property rights, the IPRs, are legal rights, says the law, attributed to creations of the human mind, which means that you have to be a human to get IPRs on something you have created. You cannot have IPRs on something created by nature. So there are creations of the human mind, such as, for example, inventions, industrial designs, trade secrets, literary, artistic works, such as books, written texts, software, music composition, aesthetic creations, paintings, lyrics. So a patent is a kind of intellectual property right. It protects an invention, and an invention always solves a technical problem. So you cannot have a patent for a music, for a composition, or for a painting. You have a patent for a technical creation of a human mind, which technical creation has to solve a technical problem. So this is a diagram, let's say, a drawing. So all of these are intellectual rights. It's not just one intellectual right, okay? So there are patented inventions, there are trade secrets for non-patented inventions, there are registered trademarks, copyrighted work, and designs, industrial designs. So actually, most of the times, a researcher who has a research output, a result, doesn't have only one of these, doesn't have only an invention which might be patented. Most of the times, the researcher will do a publication. We write a scientific paper. So he will also have copyright work, not only an invention. Maybe later on, he will set up a company. Then that company, which might be a spin-off, will exploit the results. So that company will have registered trademarks for the product, etc., etc. So keep in mind that you don't have only one of these IPRs. Most of the times you have a combination. So let's go to the patents. what is a European patent? You will see at the bottom of the slide, I put the articles. Okay, for further reading, for anybody who wants to do some further reading or research. So the European patent is a legal title granted to the owner of the invention. It confers to the owner the right to prevent or stop others from producing or commercially exploiting the invention within a specific geographical territory. So the patent confers the right to the owner to prevent others from reproducing or exploiting the patent. However, this has as a result that the owner of the patent is the only one legalized to reproduce the patent and to exploit it commercially. Okay? Because a patent actually is a monopoly of rights for a person to do such specific acts within a specific geographical territory for a specific period of time. So it's a bundle of monopolies. Here are the institutions competent for grant procedure and patent granting. First of all is the WIPO, the World Intellectual Property Organization. Here you see the logos, okay? So the World Intellectual Property Organization is the first one. The second is the European Patent Office of the European Patent Organization. Here is the logo. And then we have the national patent offices, as the USPTO, the United States Patent and Trademark Office, the Austrian, the Belgian, the German, the Greek, the Polish, the Romanian, the Spanish Patent Office, etc. Here you see all the logos. So, just a few words about these institutions. The PCT cooperation treaty and the institutions and the legal framework, okay? The PCT is the Patent Cooperation Treaty. It was signed in the 1970s, ratified by 158 countries until today. It is administered by WIPO. By filing one international application, the procedure is simplified. Inventors can choose between 158 states to protect their invention just by filing one international application. The head offices are in Geneva, and the PCT, because you are going to hear this word PCT, I'm going to file for a PCT patent. There is no PCT patent. The PCT is a part of the procedure. It provides extra time to the applicant. To do what with the extra time? Maybe to raise funds or to find to some companies to make a cooperation. So the PCT procedure is what we say an international patent or a worldwide patent. However, the PCT procedure does not lead to patent granting. It's just a part of the procedure. Afterwards is the patent granted, the patent granting within the national offices, not in WIPO Geneva PCT. The second legal framework, the second act, is the European Patent Convention. Signed in 1973, it established a uniform legal system for granting patents across member states within the EPO, the European Patent Office. It has been ratified by 39 states until today, all EU countries as well as non-EU countries such as Norway, Switzerland, Turkey, etc. By filing one single application leads to a bundle of patents in those states chosen by the applicant, as we shall see later on. Yes, the EPC leads to the grant of the European patent. This patent will be valid when it is validated in the states chosen by the patent owner. Head offices are in Munich, The Hague, Berlin, and in the end is the library. The third one is a very new one, the unitary patent. It is based on two EU regulations of 2012 and also of the Unitary Patent Agreement, which was signed in 2013, and set up a unified patent court. So the unitary patent means that after patent granting, the patent owner may request his patent to have unitary effect on the territory of the 18 member states who have ratified that unitary patent, that EUPSA agreement. So One unitary patent is valid and covers 18 states with one annual renewal payment. This, yes, leads to the grant of a unitary patent. It is in force since June 2023, which means that when the applicant finishes this procedure in front of the European Patent Office, then he gets a European patent and he may ask for validation on the 18 states without application. So he gets a unitary patent for these 18 states. Of course, he may, as we see later, he may proceed, take national patents to the other states. And the last important legal act is a TRIPS agreement, which was signed in 1994 within the World Trade Organization. It established minimum protection standards for IPRs among its 166 members. It facilitates the trade and innovation, of course, and it covers different IP subjects, patents, copyrights, trademarks, industrial designs, trade secrets. It establishes the national treatment clause, which means that the foreigners of a country which has ratified the agreement will have no different treatment than the national, and it does not lead to the patent granting. Okay, so we have a patent granting in Europe through the EPC, European Patent Convention, only. So at the end of each part, because the presentation has 8 parts, at the end of each part, I have a very compilation of, a short compilation of reference to famous inventions, just to take a short break of some seconds, and to ask any question if you want to ask any questions until now. So, inventions linking
I do,
materials.
if I may.
Yes?
The question I wanted to ask you is if there is a difference in the cost of a unitary patent compared to the previous process. So what would be, the cost of somebody to patent in several, let's say, jurisdictions, like several countries, compared to the cost for the unitary patent?
Yes, I think, Yanis, we shall see this later on this presentation. Yes. Thank you. So, inventions linking material sustainability and cultural heritage. We shall see some indicative examples. These inventions might be products or might be methods. For instance, a method or device for identifying and determining what type of material, marble, stone, etc., a monument is made of. This invention, method and device, might be a product invention or a method to produce the product. For instance, a software. Other examples, system of devices and elements, e.g., sensors, transmitters, receivers that measure data on monuments regarding the condition of the monument, its age, any cracks, humidity, maximum permitted traffic limit, etc., etc. This system of devices, of the sensors and of the screens, etc., is a product invention and or a method invention running the system, for example, with the software. Other examples, recycled cement technologies for adaptive reuse of historic structures. These cement technologies might be product and or method as well. Low carbon and ultra high performance concrete materials, often reinforced with fibers, silicon fume, etc. This is also a product and or a method to produce that product. So you may ask a patent for both product and method to produce the product. Biodegradable and compostable material alternatives, plant-based like mushrooms, or natural materials designed to break down into non-toxic components. Again, here, the applicant might ask for an invention for a patent on a product and or a method to produce that product. And recycled and bio-based materials for heritage restoration, also products and method of production that material patent. because in order to produce a material, you have the final product, the material, and also you have the method to produce that material. So it is best to ask for both. Material for repairing, replacing missing parts of monuments, and or method for applying that material. Green building materials for low impact restoration. An eco-friendly and or durable and non-toxic product for preserving, cleaning, and restoring historical structures and artifacts, or method for producing such products. Electrospan fabrics for conservation, advanced nanostructured hybrid adhesives, and eco-friendly coatings, prioritizing minimal environmental impact, low environmental impact on the object and its surroundings. So, this refers to famous invention. You see the plane, of course. Okay, it's astonishing if we see that this happened in 100 years only. And you see the Wright brothers in the middle, and some of the spacecrafts of today. So, the third part is patentable inventions, patentability, 3 prerequisites. Now, this part is short, is strictly legal. However, it's not difficult. These are, maybe some might say that these are knowledge for expertise. Maybe this is true, but they are very, very easy to acquire knowledge. It's not something difficult. So, in order to get a patent, 3 prerequisites must be fulfilled. All of them. The novelty, the inventiveness, and the industrial applicability. First of all, we have to say that patenting means that the applicant must make a full disclosure of the invention. So, the documents he has to file to be granted a patent are these 4 documents. 1, 2, 3, always. The 4th is optional. So, the first one is the description of the patent. The description of the patent is a clear and complete disclosure for it to be carried out by the person skilled in the art. So, it is not just a description. It must be written in such a way that the person skilled in the art, the expertise of that specific field of the invention, must be in a position to carry it out. So the description must be detailed. Otherwise, the applicant will get a research report from the examiner saying that your description is vague and unclear and you cannot get a patent. So we have to be very, very, very specific and clear. The second is the claims. The claims define the matter for which the protection is sought. They shall be clear and concise and be supported by the description. So we have, after the description, we have to mention exactly for which points of the patent we ask the patent, which is the monopoly that we said before. We have to be very precise and concrete. The third is the abstracts. The abstract is very short and it's not so important. And the drawings, they accompany the description if there are drawings. There are not always drawings. So the patent, so we apply for the patent and we file to the EPO or to WIPO or to the national office these 4 documents. And then the examiner will examine those documents and he has to examine whether those documents, especially the description, reveal something that is new, presents an inventive step, and finds an industrial application. So, the law says here that an invention shall be considered to be new if it does not form part of the state of the art. The state of the art is held to comprise everything made available to the public by means of a written or oral description, by use or in any other way before the date of filing of the European patent. So everything that was revealed to the public before the filing of the application is not new anymore, any longer. So the red flag here is disclosure, publication of the invention before filing for a patent destroys patentability. Professor Ogrinis mentioned that problem earlier when he said that the universities press the the researchers to reveal, to make publications, to make scientific papers, etc. So this is a real problem because all these acts such as advertising, scientific publications, selling of the product, social media, exhibitions, etc., all these acts, if made before the filing of the application, destroy the novelty of the patent. You cannot get a patent if you have made any reveal any kind of publication of the disclosure of the patent before you file for the patent. So this is number one. Maybe if you are about to keep one thing from this presentation today, please keep this one. Do not make any reveal of the invention before you file for the patent. The second prerequisite that has to be fulfilled is the inventiveness. An invention shall be considered as involving an inventive step if, having regard to the state of the art, having regard to what is new, what is known, if having regard to what is known up to date, the invention is not obvious to a person skilled in the art. So the person skilled is the examiner. Okay, the examiner is not a lawyer. The examiner is a scientist of the field of the invention. So he's an expertise. So the examiner will compare the invention with the state of the art, the known things, the known information. He has to say that what you have done is not obvious in comparison to the state of the art. If it is obvious, this prerequisite is not fulfilled. If it is not obvious, this, which is a very difficult prerequisite, is fulfilled. So, for instance, if I have this mouse pad and with a light, and I put a second light, I have novelty probably because there isn't any other mouse pad, mouse with a second light on it. So the examiner will tell me, okay, you have novelty. There is no other mouse with a second light, but it's not inventive. What you've done is obvious. It's not a big thing. It's obvious if I compare a mouse with two lamps with the previous mouse of the state of the art with one lamp. So I will not get a patent for this. It's something very easy. Everybody could do it. And the third one is an easy prerequisite to be fulfilled, industrial application. An invention shall be considered as susceptible of industrial application if it can be made or used in any kind of industry, including agriculture. And actually, all the inventions are susceptible of any kind of, some kind of application in any field of agriculture or technology or whatever. Reference to famous inventions. Here we have the bulb. And of course, Thomas Edison, who had more than 100 patents, 1,000 patents, and Nikola Tesla, who made some of the most important inventions in human history. Actually, he wasn't very much interested in the patents, Tesla. He was interested in the inventions. So, the last part of this first part of the presentation is the protection of the invention, whether it shall be protected with a patent or as a secret formula. So there is a dilemma here, a dilemma which must be faced by the TTOs as well as by the institutions, by the companies, by the researchers, by anybody. Should I patent my invention or should I keep it as a trade secret? And it is said here that what is worth copying is worth protecting. Yes. However, we must always try to find the best way to protect something, its patent. So one form of protection is the patent, another is to keep it as a secret. It is an ad hoc decision. Yes, it is a decision that it must be taken regarding the specific product or the specific method. So the question to be answered is the product or the method copyable? What does it mean, copyable? It means that is it possible for my competitor, if he examines my product or my method, to find out how I did it? If the competitor will find, by examining the product or the method, can find how I did it, I have to get a patent. I have to protect it by a patent. I have no other way to protect the product or the invention or the method. Because if he may find how I did it, he will reproduce it. So I have to go first and file for a patent and protect it before I circulate the product or before I apply the method. However, if the answer is no, if it is not copyable, which means that if the competitor cannot find out how I produce the product, how I manufacture it, or how I produced, which method, which are the steps of the method which I apply in order to make that product, if he can't figure out, he can't make reverse engineering, as we say in the software, to find out how I apply that method, then maybe the best way to protect the invention and method or product, whatever, maybe the best way is not to get a patent. Maybe the best way is to keep it as a secret in the company, in the university, in wherever, as long as it is possible to keep it as a secret. So here we see famous trade secrets. The channel number 5, it is first put in circulation in 1921. These products have known ingredients, but unknown process of production. The KFC is a secret fried chicken recipe, secret since 1930. We know the ingredients, we don't know the process of production. The Google algorithm is also secret. He could get a patent in the US as a software program, but it didn't. The stealth technology also could have produced. These are known ingredients and known process. And of course, the most known trade secret in the world, the Coca-Cola formula, secret since 1886. The ingredients are known, are on the get-up, on the bottle, on the can, but it's unknown the method of preparation. A patent will grant only 20 years of protection to all these creations, because the patent is the reveal, the specific detailed reveal of all the invention, and we saw as we mentioned earlier. So by not getting a patent, but they managed to keep it secret in the company. This is another chapter, which needs another presentation. However, a patent will grant them only 20 years of protection. So now the procedure to get a patent. Let's suppose that the decision is taken and the patent will not be kept as a trade secret, but an application for a patent will be filed. So who may file for the patent? So a European patent may be filed by any natural or legal person as an applicant. Okay. However, inventions created by researchers or employees are called employees' inventions. Employees' inventions, most of the member states have, of the EPC member states, have specific rules for the employees' inventions. So employees' inventions must be declared to the employer, to the university, to the research center, to the company, etc., as soon as they are created. This is a provision most common in all the national legal systems regarding the employees' inventions. So the employee's invention must be declared to the employer. The employer usually has no other way to know that the researcher has created an invention. It is the researcher who goes to the employer, to the TTO office usually, and declares his invention, that he has created an invention. And that usually starts the whole administrative procedure which goes through to the granting of the patent. That declaration on behalf of the researcher who did the invention. So, the protection of the invention will be according to the national legislation of the state in which the employee is mainly employed. What does it mean, this complicated provision? It means that when the researcher go to the employer and declares he has made an invention, it is the law system, the national legislation of that state where the employee, the researcher, is employed, which will dictate whether the application will be filed by the institution and the researcher, by the researcher. So it is dictated by the national legislation. The EPC convention rules the granting of the patents, but that doesn't rule that kind of national law. It is up to each state to regulate that point freely. So, in universities and research centers, national law might provide that internal technology transfer regulations apply as well, apart from the national legislation. Simultaneously, technology transfer regulations usually are applied within universities and research centers, educational institutions. The competent office usually are the technology transfer offices to carry out the process to protect the invention. Okay, they are competent to do it and responsible to do it. So, who is entitled to file for a patent in employees' inventions? And who is the inventor? So, the applicant for the patent. A European patent application may be filed by any natural or legal person, according to the national legislation, as we mentioned before, of the state in which the employee is meant to employ. Okay, the national legislation will provide who is authorized to file for the patent, the researcher or the institution, or both. That will be regulated by the national legislation. And a European patent application may also be filed by joint applicants, more applicants, to the same or different contracting states. Okay, who is the inventor? The inventor is always a natural person. You can never have an inventor such as an institution or a company or a research center, a university. No, the inventor is always a human being. A robot can be an inventor? No, it cannot. It has been judged by the court. No, it cannot. So an inventor is always one or more natural persons. They have the right to be mentioned as such in the European patent application. The researchers are always designated as inventors. They might be applicants as well, according to the national legislation or according to the international regulation of the institutions. So the researchers are at least inventors in the application form. They are the inventors or the inventors and the applicants as well. And applicants might be the university, the company, the research center, probably, and the researchers. But the inventors are always only natural persons. So these are reference to a famous invention. This is the car. This is Henry Ford, who first created the famous Model T. And also he was the first who applied the production line. Until Ford, before Ford, there was no production line. Its worker was doing the product from A to Z. He was preparing all the, he was performing all the stages of the production of the product. But Henry Ford was the first who initiated, and actually that was another invention as well, the production line, which means that each worker will make only one part of the procedure. That means that the final product, the product will be produced much more quickly and easily. Yes, because each worker was specialized in one specific sector, and this means acceleration of the product. So, the procedure to get a patent. So this is a bit complicated. We shall spend 3 or 4 minutes on this slide. It's not one patent protection. There are many procedures, many options, and the applicant has to choose which option, which kind of procedure to follow. It has to do with the budget and with the relative market, which means that the applicant might apply only for a national patent. Okay, and this is a national procedure which leads to granting and get a national patent, for instance, in Belgium or in Germany or in Greece or in Romania. Okay, but probably she wants to go abroad because the researchers and the university as well are persuaded that that specific product will find great success, commercial success in other markets abroad. So they do not want to stay only with the national patent because the patent provides geographical protection, which means that if I get a German patent or a Greek patent, only a national patent, I am allowed to produce the product only within the German territory or only within the Greek territory. It has to do with geographical territories. So, but if I have a patent in Greece, and I also think that this product will have great success commercially in Germany as well, I want to go to Germany as well. And maybe to France, to Belgium, to Romania as well, to Spain as well. So I will file for a European patent. Then I have to do this within 12 months from the initial filing of the initial national application. So within 12 months, I will go and file for a European patent. Okay, which will lead hopefully to the granting of the patent within more or less 2 years, 1.5, 3 years, etc. But I have to do this in 12 months. If I do not do this within 12 months from the first filing of the first national application, I will lose the time limit and I will I will be left only with the national patent, which means that throughout Europe, everybody will be allowed to copy the patent without paying royalties to me. It is so simple. So, okay, however, many times I don't want to go only to other European countries, but I want to protect the patent also to the US, for instance, or to Canada, to Australia, to Japan. Then maybe it is better not to go within 12 months to a European patent, but to an international patent, a WIPO PCT we saw earlier patent, also within 12 months from filing of the first Greek application, national application, whatever. So within 12 months, instead of filing for a European, I file for an international WIPO patent. Okay, there is no such thing as we saw, but there is an application for an international patent, which gives me a total of 30 months if I do this, if I file this patent in WIPO, a PCT patent. This gives me a time limit of 30 months from the first priority national patent filing to proceed then to the European or US or Japan or Australian patent. So in the first scenario, I go within 12 months to Europe, or within 12 months, I can also go to US or to Australia within 12 months. Or I can go through WIPO PCT, which gives me more extra months. Why do I need these 30 months? I need them because I want to raise fund, or I want to find in which relative markets the product will have commercial success. I want to be sure, or I want to find colleagues to make operations. So many times we go through WIPO, and then when the 30 months finish, then we go to European patent or to US patent. So it's extra time. Of course, it costs an amount of money, we shall see now, but it is extra time. And I also get a search report, an international search report here. So if I don't go to PCT, so what if I don't do any national patent at all? Yes, I do have this choice too, to begin from WIPO PCT as the first action. And then within 30 months, I will go to the European, US patent, Australian patent, Italy patent, or etc. Or nothing of all this. I will go straight forward from the beginning for a European patent. I will begin from here, and I will file for a European patent, which covers all the 39 states of the EPC. And then within 12 months, I will go to US. So just to mention that you have many options to choose. It has to do with the budget you have, because it's extra procedure, it's extra budget, and the relative market. For instance, something which has to do, for instance, with olive oil, it's not much use to patent it in Sweden, maybe. Something which has to do with procedure of wood, whatever, you have to go to Sweden. This is certain. So it's not all the patents, all the inventions for all the markets. So if I do go to PCT, I decide to go for international patent, so I'll get 30 months extra time because I need it. If I'm in a hurry and I want to go to the commercial exploitation immediately, I will not go through PCT. I will go directly to the States. But this gives me time. So if I go to PCT, so here this diagram is made of WIPO. I copy paste it here. It's only part of the procedure. It does not lead to patent granting. The administrative fees are more or less 3,500 euros. And here is the route. So the invention is here. You file for international application. We file in the national office or in WIPO. Then the application goes to WIPO Geneva. The WIPO sends the application to the authority that will make the search report for the invention, which for most European countries, some of them, is the European Patent Office. Some other countries are also examination centers, international authorities. Then here, it is set up and issued the international search report, which is very, very crucial and very important, because this report explains to the examiner, to the applicant, the opinion of the examiner regarding the invention. So here the applicant has a first written opinion of the examiner stating whether he will probably get a patent or not, because the examiner includes in the international sales report all the previous application, the previous patents, the state of the art, which the examiner considers to be relevant to the invention. So he has a first opinion whether he will get a patent later on or not. So this is very crucial and very important, because if the report, the ISR, the international sales report, is let's say positive, so the applicant has a reason to go further to the procedure and spend more money to get a patent. Otherwise, maybe he will choose to stop the procedure and not go further. So he gets the search report here, and then WIPO sends the search report to the applicant and also to the states or to the other offices. And here the procedure stops. He hasn't get any patent yet. So if he want to get a patent, then he will go on to the national procedure. Here it is the national patents. Then he will proceed for this procedure. So the PCT procedure stops here when the WIPO communicates the international sales report to all the offices of all the states. Okay? So here the procedure stops. It costs that amount of money, and also, however, it gives 30 extra months. So if he proceeds, for instance, here, the applicant wants to get a European patent. Okay? So here, when within the 31 months, 31 is for Europe. For other countries such as US, it's 30 months. Within 31 months, he will file for a European patent and start the European procedure. So the legal protection in Europe is through European Patent Office, EPO, Munich, The Hague, and Berlin. One patent application covers all 39 states, as we saw before, contracted to the European Patent Convention in 1973. So all these 39 states have ratified the EPC convention, and they are not only the EU member states, but also Turkey, Norway, UK now, etc. Switzerland. So, step one, the EPO makes substantive examination of the patent application in order to decide the patent granting. The examining division might ask for amendments. Interaction with the examining division. Yes, this is the heart of the procedure. This is the stage where the examiner will decide whether the patent will be granted or not, or whether amendments are necessary to proceed or not, whatever. This step lasts 1 or 2 years, and there is a continuous interaction between the applicant and the examining division. And step 2, if the European patent is granted, the invention is protected only in those European states that the patent owner chooses to validate the patent, which means that the EPO announces that the patent will be granted, but this is not the end of the procedure. The applicant has to proceed and go to the states that he chooses to validate his patent. If he doesn't validate the patent in the states, the patent has no legal force. So this is a famous photograph regarding telephone. Is Graham Bell placing the first New York to Chicago phone call in 1892, as you see here. And of course, the room is full of reporters, whatever, journalists, etc., etc. This is Graham Bell. And here we are today. So procedure to get a patent. Granting, states, unitary patent, national patents. So, validation of the European patent. As we saw, he is granted the patent, okay? The European patent announces the granting of the patent. So, this is not the end of the procedure for the applicant. He has to go on to proceed and within 3 months to validate the patents in some states, or 1 month to get a unitary patent, which is something new in the European patent system. So the European patent produces legal effects only within a specific geographical territory, states, chosen by the EP owner. He has these options. He may ask within 1 month from granting, he may ask for unitary patent. One unified patent which covers 18 states until today. Romania was the last state that ratified the unitary patent. So if he goes for a unitary patent, he may ask it within 1 month from granting, and he will have one patent covering 18 states, and for the renewal each year will pay only once, which is very useful to the applicant, to the owner of the patent. The second choice is to get this, or not to get the unitary patent at all, but to ask only for national patents to specific member states. Validation procedure state by state. This is an expensive procedure that used to be the situation until 2023, when the UP came into force. We had to validate the patents to every state separately, to 5, 10, whatever, to pay national fees and legal fees to each state separately. Very expensive procedure. So if he decides to get a unitary patent, he will have one patent for 18 member states. These are the states: Germany, France, Italy, Romania, Belgium, Sweden, Luxembourg, Malta, the Netherlands, etc. They are here. He may take the unitary patent a start. Maybe he's not interested in other markets. Maybe his products will have a great success in these markets, and the owner is completely satisfied. Maybe he also wants Greece, for instance, or maybe he also wants Spain. Then he shall go to the by the traditional way and send his patent for validation separately to Spain and separately to Greece to have this patent validated, which means to be enforced, to become enforced in those countries as well. Okay? And he has 3 months to do this. These are all the 39 member states of the EPC. So this is another famous invention of Thomas Edison. And information regarding administrative fees and relevant renewal news, and some points for the TTOs. So the procedure to the EPO has an approximate cost of 6,000 euros, which are the fees without the fees of the patent attorneys and of the technical advisors. Okay, these are the administrative EPO fees to file the application, to have a European search, to designate the states, and to have the application examined. Okay, there are reductions for SMEs, for educational institutions, for natural persons, etc., and for the European countries who do not have German, French, and English as official language. The reductions are up to 30%. So I would like to close the final to close this presentation by using the final moments to these last two slides regarding some points that should be mentioned for the technology transfer offices. Hopefully they will be of some use. The confidentiality is the first one. The TTOs and the staff in the TTOs must keep secret confidentiality at least until filing of the patent application. This is very crucial because, as we saw earlier, the patent is not protected as long as an application for a patent hasn't been filed. So confidentiality is very important because if the patent is published in any way, it is a novelty, as we saw, novelty is destroyed and you cannot ask for a patent any longer. So what kind of patent to choose? What we saw earlier, only national patent, European patent, unitary patent, US patent, Australia, what? There has to be conversation and interaction between the TTO and the researchers regarding the relative markets because, of course, the TTOs, usually they have a marketing team. However, the researchers know that field, specific field of their invention actually more than anyone else. And the conversation interaction will be useful to determine the marketing policy and the kind of the desired patent and those markets that the product will have a successful exploitation. The third point is recording of innovative research results. Yes, the TTOs has to record the results and has to implement of the results the national legislation and the internal university regulations for the legal protection. The fourth is the creation, if there isn't any, the creation of a registry, of an innovation registry. This is very important for the better surveillance and maintenance of the patents and for monitoring the due payments of license fees because usually the patents are exploited. This is what we all are trying for. The patent to be exploited by a company, by somebody, okay, that somebody who will exploit the patent will have to pay royalties. So somebody has to monitor whether each year the royalties by the licensee have been paid. Okay, otherwise the patent is not exploited in the right way. This is something that has to be done by somebody, and usually that somebody is the TTO. Also, usually the TTOs are responsible for handling the entire process through a specialized lawyer or patent attorney who will represent the institution in the patent process. There is a need to frequently receive a detailed report from the attorney on the progress of the case. Okay, the TTO has to be updated, informed each day, each time of the procedure at the point of the precise point of the procedure where the application is. The sixth is that usually there are more applicants. Usually it's not only one university. usually there are more universities, more educational institutions. There has to be, in any way, one or more. It has to be an agreement which must be signed before filing for a patent, stating the IPR's percentages on the patent of each party. If that agreement hasn't been signed when the search began, it must be signed before filing for a patent. That agreement will set the IPR's percentages of the patent on the patent of each party. For instance, University A might have 20% of the patent, University B 80% of the patent, or 50-50, or whatever. The parties of the agreement might be universities, institutions, and or researchers maybe, and or private companies. It depends on the national legislation, as we mentioned earlier. But there has to be this agreement because the ownership on the patent means the right to get a certain percentage of the income, okay, of the income, of the royalties of the patent. And finally, the duration of the European patent is 20 years from the date of filing of the application. So, in order for the patent to remain valid, the annual fees must be paid each year, during a specific month, the anniversary month. Okay, so the annual payment of the renewal fees paid once every year in the anniversary month for 20 years in every state, or the patent will lapse. Consequences of patent expiration or lapse: pre-exploitation of the invention by anyone without paying royalties. So, this is something, the monitoring of the fees payment is something that has to be done very cautiously, and actually it has to be done probably by the TTOs, because if the annual fees are not paid in time, the patent will lapse. So, this is a case example of patent lapsing for not paying renewal fees. Yes, the renewal fees could not be paid, and the patent was lost. And everybody then can copy this toy without paying anything to the applicant, to the patent owner. So the final famous invention, the train. And here is something that was published last week. That's why I put it here. Maybe it's of everybody interested to know it. The technical fields with most patent applications in 2025, published by the European Patent Office in 2026. So here you see which technology and by which states is preferable, who filed the most patents, for which state filed the most patents, as for which field. And here you have you see the percentage in comparison to last year, whether there is an augmentation or a reduction. Computer technology is on the first rank. Then digital communication, electrical machinery, apparatus, energy, medical technology, transportation, measurement, biotechnology, pharmaceuticals, other special machines, and organic fine chemistry. Okay, thank you very much for your attention. And if there are any questions, I will be more than happy to reply.
Thank you very much, Dr. Panagiotou.
Thank you.
For this insightful speech.